education meeting, if you will. And first and foremost, the most important thing for everybody to understand is that we are recording this meeting. Unfortunately, we've had a few requests from participants with regard to third-party apps. Unfortunately, due to compliance reasons, we are unable to allow those in for the meeting. But with this recording, we will have it available for you to be able to view at some time in the near future after its completion. But anyway, with that being said, we've got a great lineup for you tonight. And first and foremost, most important is we're going to cover a lot of information. Maybe not all of it will pertain to you, but please, there may be certain parts that do. But it's a fascinating topic of estate planning. And without further ado, I'll pass it on to my business partner, Robert Young.
We have Daniel Esparza on tonight, who's an estate planning attorney with us. If I rethink this based on the time of year, I might have brought in an allergy doctor because if many of you, like me, can't get to these allergies. So if you have a cure for that, let me know. I don't think I know that stuff too. So anyhow, what we're going to do is we're going to do a little go over a little estate planning today. But let me first of all start off with a bio of Daniel. So Daniel's one of a number of different estate planning attorney firms that we work with. We have a good close relationship with him. He was introduced to us by a good longtime client of ours, and we've had some successful relationships that he's helped us with, and it has been great. So let me read your bio, Daniel. So not that you don't know this, but Daniel obtained his JD from Indiana University Maurer School of Law, where he served as an associate and assistant editor for nationally recognized Indiana Law Journal. He concurrently received his MBA from the globally recognized, I'm not going to even try this one, so it's called SKK University Graduate School of Business in Seoul, South Korea. And he is admitted to practice in both state and federal court in Arizona. Daniel was born in Oxnard, California, raised in Peoria, Arizona. After completing his education, he began practicing primarily in the areas of estate planning and business law, extremely helpful. He later added probate litigation as a practice field to better serve his clients. His litigation experience includes trustee removal, undue influence contests, and successfully challenging admission of a foreign will on the basis of fraud. Good for you. Daniel's current area of practice includes estate planning, probate, guardianships, and conservatorships. So this is a mouthful. So a lot of fun stuff. I remember, bit over 20 years ago when I got into the business, I thought I was going to get into this business to help people with things like insurances and investments and retirement accounts and all those fun things. And then one day we started looking at this and realizing there's a whole lot more to it, other things to talk about. So tonight we're going to focus on estate planning. And so we're going to talk a little bit about, a lot of people think of estate planning really as just a trust or a will. It's so much bigger than that. It's so much bigger than that. And we're going to call this a 101 class, and hopefully we're going to have Daniel back again in the future to maybe dig into this a little bit deeper.
That'd be fun.
But I think we'll start out by, why don't you just give us a little bit about your background and the firm's background itself.
Sure. So, excuse me, speaking of allergies, right? So thank you, Robert, very much for having me here today. So my practice area is, not that it really matters to everyone else, it's Title 14 of the Arizona Revised Statutes. So that would be everything from probates to wills, trusts, guardianships, everything within that. And somewhere around the peripheries, because they kind of go into other areas too, is charitable remainder trust, elder law, so like Medicaid planning, for example. The firm itself also does family law. That's not my area. That's the other half of it. And that would include things like child support, enforcement of orders, divorce, and things of that nature.
Great. And okay, so I think let's get to it. So I think Daniel and I spent a bit of time on the phone multiple times kind of preparing for this. It's such a large animal to eat. We said, let's just, figure out one bite at a time how we're going to handle this. So let's get into just, kind of the starting at a 101 level. And I think that is just a simple explanation of what is a trust and then what is a will, because there's a lot of confusion.
Oh, yes, absolutely. So what a trust is essentially it's a vehicle for avoiding probate. That's what most people use it for. I mean, there are many different types, but that's the type that most people deal with. A will, on the other hand, it's you saying what you would like to have happen upon your death. It's not necessarily effective during life. Wills are only effective at death. Trusts, however, can be effective during your life, and they can actually use serve a lot of useful purposes for that.
Excellent, excellent. And I think at some point we're going to get into a little more detail on, incidents that have happened in the past. We've both seen them where somebody didn't have these things in place, and what the repercussions were, and also the good side of it where they did have it in place. It was extremely helpful. We've witnessed that. So, in layman's terms, now that you kind of explained what each one is, could you explain the difference? Because what we get is a lot of clients that come to us and say, well, I have a will. Doesn't that cover everything a trust does? What's the difference? So to just the layman, what's the easiest way you would explain to somebody what's the difference between what a trust is supposed to do and what a will is supposed to do?
Okay, so in layman's terms, a trust, you could say it's used to hold assets in order to avoid probate, because the way I usually describe it is that kind of like a mini holding company. Is a little bit different analogy than we just talked about on the phone, but think of like a mini holding company where you put all your assets into it, and you still control it, but you're not the record owner, so your name's not on there, which means the owner didn't die. So we don't have to say, oh, well, probate's triggered because the owner's died. That's usually the rule, right? In this case, technically the owner didn't die, but you're the one behind it who is no longer there. But the identity of the person entitled to the benefits of the assets in the trust does change. That goes according to the way that you want it to go. And that's how we use it in a way. It's often called a will substitute, because it does the job of a will a lot of times. However, it is different than a will. A will is you as an individual saying where you want things to go, and it's very important to have that. You can't substitute with just a trust, because anything that's not controlled by the trust is just not going to it's not going to be covered by it, and sometimes that can be a real issue. I think it has.
Perfect. Yeah, and as many of you on this call or that may listen to this recording may know, you may see a situation where somebody has a will, but they don't have a trust in place. But you're not going to really see a situation where they have a trust without a will. So part of what your firm does, and you now head, and congratulations, by the way, on the you are now heading the estate planning division for your firm. That's excellent. And so I'm sure you see people come in and they just have a will, but when you do a trust, you also would do a will for them as well. Okay, good. That's a great, concise explanation for it. That's definitely, I think, a point that a lot of people just really misunderstand. I don't know if there's anything we do that probably has more misunderstanding around it than wills and trusts.
Yeah. Would you mind if I just give you an example
Absolutely.
of how that would be a difference? So this is something it's wonderful when life throws something at you that that it just all of a sudden a bunch of situations like that come, and it's just illustrates the reason for having something. So I have had a few clients where they have a trust and they have a will, or actually rather it's the client has passed away. Now the kids are here, and I said, well, what do you do? The cars weren't inside the trust. And I said, well, I did that on purpose. The cars, even though the financial accounts all went according to the trust, that was easy for them to understand, but they didn't understand the cars. They're like, oh my gosh, this is the cars are not there. I said, no, don't worry about it. There's a law that says that if you had everything else taken care of, and it's really just a few vehicles that are now under $200,000, the amount just went from 75,000 to 200,000, which is great. But if you have vehicles less cumulatively in total, less than $200,000 in value, you just take the will and the trust to the DMV or MVD and have them sign a small estate affidavit. It transfers to the right person. You still avoid probate. But if you didn't have the will, also, it wouldn't have worked. You would have ended up in probate.
Okay. That makes sense. Yeah, that's good that they raised that too, because I mean, with the cost of cars nowadays, I mean, $75,000 is like a used Ford F-150 and maybe a used Tesla, and you're well over that $75,000 mark, and just like that. Okay, so I know you would typically do a will if you're setting up a trust for a client, but when should a client, we do get clients that have maybe a very simple situation. Perhaps they own a home, maybe it's paid for, simple, have one kid. They just, an IRA, it's fairly simple, and they just have a will in place. What kind of situation would arise where you would just have a will in place, or if somebody just had one, we would say, yeah, that's fine. You probably don't need a trust.
Yes, I would say it's a great question, and it comes up all the time. there's no bright line rules, in many cases. So my evaluation starts with complexity. If things are complex, that suggests more of a trust. So, for example, if you have an older client, they've got, let's say, widowed and 3 grown kids, doesn't really matter how many. She wants to leave everything to them evenly. There are no minor, like I said, no minors involved. That's very important to remember. Then maybe non-probate transfers or transfer on death designations, beneficiary designations in layman's terms, are sufficient, because those by statute say anything in that account is distributed by the account holder, by the institution, directly to those people. They'll cut separate checks. So there's really no administration has to happen. And if that's all you need, that's all you need. It might not be worth it in their situation to have a trust, because ultimately it's going to go that way anyway.
Yeah. So what you're saying, and I might want to highlight this is, but you want to make sure those TOD or transfer on death accounts are properly set up and they have the proper beneficiaries on it. Because we have seen situations where maybe a beneficiary died some years ago, and now there's either no one on that old account, or maybe something's changed. Again, many times it's a change of divorce, something along those lines.
Yes, and that would actually be one of the reasons a trust is actually very useful. It's very good for organizing things, because once you put everything into the name of the trust, if you need to make a change, many times you can just go to the document itself and change the beneficiaries on it. But everything already is referenced on the financial accounts, on whatever it is you might have IRAs. So you don't need to update it for situations. When I write a document, that's why trust can be so big, is I take into account many different situations, but financial institutions, there's limited in the amount of lines that they can put.
Yes. Yeah, that is, I think it's really interesting. So just kind of recap complexity, because you could have a client that has several $1 million in one IRA, one beneficiary. It's fairly simple. You could have another client that has a third of that amount, but they might have another rental property or a vacation home, and then they've got kids from multiple. We ran into this. I just the other day met a couple. They both have kids from previous marriages, and they have one child from their marriage. And I don't know how you would do that with just a will. A trust is really going to cover more of that complexity.
Oh, certainly, yes. And you will get into that later, I'm assuming.
Yeah, if you want definitely. If you want to jump on it now, let's do it.
I would say just to tee it up for later is that's why we said complexity. It's not amount of money necessarily, although that is a factor of it. But that's a complex family situation. You can't just write, I want everything to go to this person. That's just one line in a trust, the operative line. But the other situation, that's like 5 right there easily. That just as an example.
Yep. Yeah. And like I said, as things change, we'll get in a moment. It's necessary that you make some updates. So let's go into other things that are important once your trust is in place. I'll let you start with that. I know it's funding, beneficiaries, things like that, but you want to kind of explain that. That's the number one thing we get. People come to us and say, I went to my estate planner and they said, we need to fund the trust. And they think that means putting some money in the trust, which you can't really do. Maybe you could go through what that means. So a client does have their trust finished. What are some of the things they should make sure that are done now that that's finished?
Well, let's say, funding, of course, is the first thing, because if something is not inside the trust or connected to the trust in some way, it's useless. Again, the vehicle example is a great one, because we do that on purpose, because it's annoying to put vehicles into a trust. Try selling it from there. Don't try that at home. Right. So in that situation, you want to make sure that you do have the right things inside the trust, because if you don't, you're going to end up in probate anyway. I've had plenty of people, and this is a pet peeve of mine, is when estate planning attorneys don't make sure that they talk about what you need to go do after you sign the trust. But if you do that right, you won't have probate. If you don't, the trust is just an expensive piece of paper. Other things I would say is making sure that you have it reviewed every 3 to 5 years. At least check in with your estate planning attorney. Maybe the laws change, and you want to make sure that you have the latest things, and maybe you didn't even think about something being a big deal, and so you want to make sure that those things that you have somebody who can take you from a different perspective, look out a little bit, and see, oh wait, this was actually a very big thing.
Yeah.
So yeah.
Well, I think while we're on that subject, something that you mentioned earlier, again, updating things like beneficiaries. We see often that we'll have a client who used to have a brother or a sister, or sometimes even a parent, and now this client's 80. Their parents have been gone for 20 years, and the parent literally is a trustee or a beneficiary or something on the trust itself, and it's not been updated. So definitely updating those. And you want to just give them a simple explanation of what funding really is, because it's a very simple thing.
Yeah, funding, that comes from, which is more or less true, that you need to put things into a trust. You actually need to title things in the name of it. In Arizona, it's not exactly that way, but for our purposes, it's fine. That's what people mean, though, is they want the name of the trust to be somewhere listed on the record for that item, whether it's as TOD, a transfer on death, like you might do with some of your IRAs, hopefully after the spouse, right? Because we want to get the full stretch on that.
Absolutely.
But you want it somewhere on the paperwork, and of course, the place that I say that you should put it.
That's right. Yeah. I might add, most good estate planning attorneys, Daniel included, will send us to the client, or send it to us with the client's permission, a list of the things they need to do. So funding, meaning, okay, well, now we want the trust as a beneficiary on the investment accounts. Where do we want them on there? And that's something, since you hit on it, for those of you that have IRA accounts, things of that sort, IRA has some special rules. And one of the special rules that they have, and it actually changed quite a bit after, I think as of 2020, the law was changed in 18, went in effect, I think in 2020.
More or less. I get confused with the 1.0, 2.0, that kind of stuff.
Yeah, Secure 1.0, Secure 2.0. And the difference is, it used to be that you could stretch out an IRA over time. And what does a stretch mean? It means that if I died and my spouse inherited the money, they can stretch it out. In other words, they can take required minimum distributions over the rest of their life. But let's just say that my daughter, or a because there's just, now it's simple. It's a spouse, non-spouse. This is two things. So you're either a spouse or you're not a spouse. Doesn't matter if it's your daughter, brother, cousin, or best friend that's inheriting the money in an IRA. They have 10 years to get it out of there. That's assuming that they're taking their proper required minimum distributions every single year. If you miss them, then those rules change, and it can be shrunk down to as little as 5 years. So something to be very careful of. We get clients asking this question all the time. Does the trust go first? Does the spouse go first? The simple answer is, and you said it earlier,
the spouse goes first 99% of the time. I'm going to say, I mean, in this, you're doing that on purpose, and the consequences, because sometimes you value something more over another. You always want the spouse.
That's right. Now, if it's a situation where, let's just say, someone is unmarried or they're widowed, and they don't have a spouse, and they have 2 kids, 3 kids, something like that, then putting the trust on there first, putting the kids on there first. What are some of the differences in that? Because these are really common questions that we get. And coming from you, how would you handle that question?
I generally try to, because I also go to court. Thank goodness, not every day, but because I have this to balance and keep my sanity. Sorry, excuse me one second. Pardon me for a second.
So we're going back. So if we have a situation where there's no spouse,
3 kids, no
and we have 2 kids, we put the trust to the kids.
I typically put the trust. I make my trust so that they can just be listed.
Yes.
And the reason for it is not that it's just, and not that you couldn't put your kids on there. I try to make sure that there's no mistakes, and that's what I was getting to when I, took that.
That's happens all.
But so I want to make sure that it's very easy to just put one name down there. I don't want you to say, oh well, put these people there unless this happens and all that kind of stuff, because I don't know what's going to happen in the future of your situation. Right. So I don't want to be easy on the the bank and whoever's holding that account.
That's right. That's right. No, good advice on the car, good advice on all that stuff in there. Another real common mistake that we get people asking about is, I just had one the other day, talking actually to a friend of a friend that I met with the car club that I belong to, and somehow it came up when I did, and he said, I don't really worry about it. I'm covered because I have my stuff in a trust. And I said, is it just a revocable family trust? And he said, yes. And I said, well, that actually doesn't cover liability from creditor claims, etc. Can you kind of explain what a trust doesn't cover when it comes to creditor claims?
So not all trusts are created equal. They all are different on purpose. Most people, they need a revocable living trust because they want to have control of their assets and they don't want to have to pay more tax. There can be problems with that. Plus, it might not do you any good anyway if you had those things. If you're the one funding the trust, that's very important. A grantor only trust, especially in the state of Arizona. Those typically don't offer any protection. So the reason for that again is because the state doesn't really want you to just shield your assets from everything. Now, there are other ways to do that, but that's just not the way.
Yeah.
You might combine this with LLCs if you have a rental, and that can be held in a trust or somehow connected with the trust.
Yes, absolutely. Yeah, and that's why we have a lot of clients that have rental properties. This is not necessarily for just a second home you use. I'm talking about a property that's an income property. It could be a house, it could be a commercial building. And what I often see is they own it outright. They don't have an LLC, and then they're holding the shares in the trust in there, which is not great because it still gives liability out of the trust where it should be held in an LLC, and then the trust itself could own the shares.
Yes.
But that protects so that if anything happens on that rental property, at least they can only go after what's inside of that LLC, and hopefully, if you own those properties, you have separate umbrella coverage as well.
Yes.
So that if you do get sued, then
it is the first line of defense. I recommend that to all my clients. They at least look at that even before LLCs.
Yes.
Insurance comes first.
Absolutely. So let's move on to irrevocable trust. I'm not going to spend a lot of time on here, but we do have clients that have substantial amount of assets. And those assets, they're getting up in years and they're beginning to get to that point in time where they're saying, hey, I want to make sure this goes to my kids and there's something to my grandkids and maybe to a generation that they'll just really never even meet. So let's touch on irrevocable trusts. And there are many times where our conversations will just stick with irrevocable trust for the time without going into details, how they can protect.
Okay, yes. So irrevocable trusts, they're sometimes created right away. Other times, your revocable trust can have it always becomes irrevocable when you pass away. That's one thing. That's when you can't use a security number. Right. You have to use an EIN, tax ID number. But you might set up your trust to continue as an irrevocable trust, shielding those who were not the grantors, they're not the creators of it and funding it. That money or assets were never theirs.
Yes.
And because of that, they can be prevented from fully reaching the beneficiary and therefore being subject to a lawsuit.
Yes.
So let's say two situations, I guess. You have one maybe where you're just worried about a kid who might not have made some wise decisions.
Spendthrift.
That would be the old term for it.
There's always one in the family, right?
Well, yes, very often. So in that case, you're shielding that person from being able to have full access to it, but you might have a wide standard, health, education, maintenance, support, very common HEMS. So the trustee would technically manage it, and usually you don't want the kid to be their own trustee. Sometimes it's okay, but generally not in this situation. And that trustee will approve when certain things can be spent for that person, for the beneficiary, or they might just give money out if that's more convenient. The other thing would be a special needs trust. If you don't want you don't want a child, say, who's the one that comes to mind is like someone who's severely autistic because they're getting government benefits. It's just a very common thing nowadays. But you don't want them to lose their government benefits if they get an inheritance. So you never want to leave it directly to them because that's going to say, oh, well, the government says you got a bunch of money. You don't need this now. Well, that doesn't technically go to them. The special needs trust is designed to shield it from them, but it still can be used as a supplement. It says it has very specific terms saying only certain amounts of money not to disqualify this person can be expended.
And since you obviously work in the state of Arizona, something that, in fact, this came up on a conversation recently, we were doing what we call a family meeting. By the way, those of you clients that are listening to this, if you haven't done a family meeting with us and you have, adult children that you would like to have on a call, and we usually recommend just your kids, not daughter-in-laws, son-in-laws, that sort of thing. We'll do a family meeting with them and they get to introduce to us, that sort of thing. And we can talk a little bit about, to your comfort level, what you have, mainly your kids. Most kids just want to know mom and dad are fine, they're funded, who are you guys if something happens. But one of the questions that was asked to me is, well, Robert, if my parents die, they have a trust. So what happens? I just open up my own trust and then I'm good. And then that protects all the assets. And I said, well, not really. That's still not going to protect the assets. So can you kind of explain this so that, and for the sake of time, I'm going to keep this at a kind of a high level. So mom and dad were to pass away. They leave 50% to the son, 50% to the daughter. The kids each traditionally will set up their own trust,
Mhm.
let's say,
Mhm.
right? Because the other option is maybe they mix funds with their spouse. They get divorced, spouse gets half of mom and dad's money, which
Yep.
okay. So that usually happens. What is, first of all, what would happen with that situation? How the courts look at that. And then if they didn't want that to happen, how could they protect that to keep those family assets?
Right. So default situation would be if you just left it to them outright. It actually would be separate property still. So as long as they don't commingle it, don't
Right.
mix it with their spouse's money, so you can trace it, they put it in a separate account. That's still fully theirs.
Mhm.
Now there's more manipulation that could happen there, dynamics, all that, but that's technically okay. Now, what the benefit of setting up something like, you might call this a dynasty trust. That's meant to last multiple generations. So let's say that is the situation that we're thinking of. Well, in that case, you set the rules; they can't change it. So they're like, "Well, it's out of my hands. What can I do?" I mean, there's no interspousal conflict. At least there shouldn't be there. There might still be some anger, but that's another story. That's one thing you can do, is you can keep it from them, and that way it can't be mixed up, because it has to be put in a separate account, has to be titled with the trust, and then it might even continue for the generations staying down the line, and whether or not, unless you specifically mention it, whether it's in a dynasty trust or whether it's just outright to the children, it's going to go by bloodline. It's not going to go to the spouse if something happens to that child. Under any kind of traditional wording, you have to specifically say the spouse is going to get it.
Okay, perfect. So what you're saying is the default would be to go down the bloodline. So it's going to go to your kids, their kids, their kids. Yep. Okay.
Which
So
is
that's
very different.
Yeah.
Then very different. Even though you're like, oh well, it's really she has to. Maybe not. No, that's a very different thing legally speaking.
Absolutely. Absolutely. And so what you were talking about when we get into things like dynasty trust, and that's one of many more complex, that's where you start getting a situation where you can protect the assets.
Yes.
In that from the future.
Yes.
And there's more complexities to that. Yeah. And that's why they come meet with you.
That's right.
You can have that conversation. We're getting toward the end here, and this has been great. I mean, many times you start talking and I come up with more and more questions just as we're moving along. So the 2 or 3 most common mistakes you see where maybe with clients that have not, either they've had issues after death, or they haven't set up the trust right, or they haven't funded. What are 2 or 3 things that you've seen them do that, it's cost them a lot? We see this with celebrities and other people.
Yes. Well, 3 more comments. It's a bit hard to narrow down. The first one is lack of funding, because you see that people don't go take care of their trust, just like I mentioned a couple of times before, and you end up in probate anyway. And that, like I said, even if some of the money's taken care of, well, you really didn't need the trust to begin with, I guess. Next thing would be is say putting co-trustees who don't get along with each other. It brings chills. And I suppose the last thing would be not seeing an attorney, I guess, to go and get your estate planning done. And I know that sounds self-serving a little bit, but the thing is that if you go see a legal document preparer, for example, or even go to, well, if you go, let's just say legal document preparer online or in person, they can't give you legal advice.
Yes.
And so they really can't tell you if this idea is good or not. And so I mean, I'm glad they're going to somebody, but it's really good. At least find someone that you trust, and at least meet with them and have them look over what you did with them.
Yes.
I've done that for people, and sometimes I said, well, this is kind of okay, but then there's this thing that came up. But at least, and I'll tell them how it is. But that does involve finding someone you trust very much.
Yeah, it is very nice for those of you. Something that's come up a number of times with my clients. I've seen a situation where they've gone to a credit union. The credit union is offering them a very good deal on the trust. It's not being prepared by a licensed attorney in the state of Arizona.
That's correct.
Actually, it was done by a paralegal who is not a licensed attorney in the state of Arizona. And they sent me everything, the client did, and I said, well, how do you want this funded? There was a number of complexities. They gave me this person's name. I picked up the phone, I called them, and they said, I'm not an attorney. I can't tell you how to do this.
Right. That brings you right back to the funding issue, is that you're not going to get that at all.
Right. And so now if I can't fund it, in other words, put the beneficiaries properly on the items that are identified in the trust, what's the point of having it?
Right.
And so I would highly recommend that you'll look at actual attorney that prepares trusts, not go the other route. I know maybe it's half the cost of what it costs to go to an attorney, but the guidance that you get, stay away from LegalZoom for $9.99 or whatever, plus all the add-ons that you have on there. You'll pay for that in the end, or your heirs will, and we've definitely seen that.
Well, this is why I went into probate law as well, because whether you see me now or you see me later, it's either way. There's a need.
Which one's more expensive?
Definitely the after.
Yes, get it done right up front, because it's a lot more expensive down the road. And but we've even seen situations where it's a spouse or a child that's inheriting it, and they're obviously do that. But sorry, I got something in my throat here. Excuse me. Any other advice for our clients that you would recommend?
Well, I would say what I just mentioned a moment ago, and that's go see an attorney you trust. Not every attorney is equal like anybody else. Not everyone's the same fit for someone else. There are certain people that don't get along as well with me, although I hope that's very few and far between. But if I don't, I have relationships with other attorneys for this reason, because if I can't help you, I at least want to be able to say, I know the perfect person for you. It's especially helpful in other states where I'm like, I don't practice there, but I know the guy. So that's what I would say. Find someone you trust, someone obviously knows what they're doing, but someone that you think has your best interest at heart.
Perfect. I'll turn it back over to Gavin to lose my voice here. Sorry. Thank you, Dan. Appreciate it.
Thank you, Robert.
Everybody have a good night.
Thank you.
Well, thank you, guys. Great job. Full of a lot of information, as we had promised. Anyway, with that being said, if you have any questions, please reach out to us. We're more than happy to be able to explain this in further detail, and also provide you with Daniel's information as well. We also have some other trusted business partners around the valley, depending on where it is that you live. But with that being said, at this time, we're going to visit with Adam Carlett, one of our other business partners here at One2One, for a market update. Adam?
Thank you, Gavin. Good. Thank you, Robert, and Daniel as well. I'll give a brief overview of the stock market this year. I know we've seen a lot of ups and downs. I'll talk a lot about some of the major indices, S&P 500, NASDAQ. As you know, if you invest with us, you don't ever have 100% of your money in one area or one index, but we've seen a lot of turbulence, to say the least, this year. But we're not, we've had this before, right? This has definitely happened in the past, and as recent as 2022. But a little bit about the market right now. The S&P 500 is down a little over 5% for the year. Now it's down just over 9% from its highs on February 19th of this year. But we saw from February 19th to April 8th, where it dropped about 19%. So, quick drops, which again, we went through that in 2022, definitely 2020 with COVID. We had a down market in 2018 as well, until that rebound. But those were all areas where we saw quick drops and rebounds in 2018 and 2020. But April 9th, this is why we have a plan in place for everybody. We plan for the ups and downs. We saw on April 9th, the S&P 500 was up over 9.5% in one day. Its third largest ever percentage gain in a day. The NASDAQ on that same day was up over 12%. It was its second largest percentage gain of all time. If you would have told me on April 8th, will that happen on April 9th? I would have said there's no way. But this is why we diversify and plan for the ups and downs and stay invested. Everyone in here has their own unique plan, and we expect this stuff, right? We have the NASDAQ. The NASDAQ is down over 9.5% for the year, but it is down over 13.5% from its highs on December 16th of 2024. And we actually saw it drop a little over 24%, from mid-December until April 8th. As I mentioned earlier, the NASDAQ was up over 12% on April 9th. So these have been big moves, and it's almost a whole year of returns in one day on April 9th, right? But then again, here's why we diversify in international. The international EFA index is actually positive, just under 10% for the year, right? The stock market has averaged pulling back and being negative by 14% per year since 1980. So these are normal things that obviously we don't love. We love when it just goes straight up. but these numbers kind of give you an idea of what's really going on in the market. I know it can be scary, especially because it does move quick up and down, as we've seen, right? But we're not even close to what it did in 2022. And a lot of people on this call, whether they've been investing with us or we're investing somewhere else in 2022, we're in the market. The S&P 500 was down over 27% at one point in 2022 and ended the year down over 18%. That's the worst year since 2008. And then bonds actually had some of their worst years of all time in 2022. We got through that. We weathered the storm, but we saw intermediate term treasury bonds were down over 10% in 2022. And the average 30-year bond was down over 27% in 2022. Its worst year of all time in a lot of categories. And some of them, you hadn't had those numbers since 1980. So it's been a long time since we saw stocks and bonds do something like that. But we saw a heck of a rebound, right? In 2023 and 2024, market was up over 20% in the S&P 500 in both those years. But we've seen tariffs multiple times. Again, we know it's scary. We saw some in 2021 and 2022 with the semiconductors, which really affected the technology sector. But then we saw a big rebound in the NASDAQ, which is mainly technology companies, did over 40% in 2023. But we implement financial strategies tailored to your specific needs and goals. No one in here is invested because they're a certain age or hey, they're retiring at this date. It's all about your specific goals and what your needs are. And we base that on your long-term horizon and your objectives. So please talk to anyone in your advisor about your specific goals if you have questions. We know there's been some volatility. We do expect it, as much as we'd love it just to go straight up. We do know there will be ups and downs along the way, and we need to make sure this money lasts your entire life or for your specific goals. So just give you a brief overview of the market, and most of you have already been through this. As much fun as it is going up, I know it's not as fun going down, but this is very normal, as I mentioned, with the average market being down at least 14% per year dating back to 1980. So please reach out to any of your advisors if you'd like to chat in more detail, and we can definitely go into more detail about your portfolios because the average person here was not down near what the numbers are showing that I just mentioned, because we diversify. We own different strategies, own different parts of the market, different types of investments as well. And we can go into detail with you specifically on your own portfolio if you'd like. But thank you for your time tonight. Thank you for allowing us to give you a brief update on the market and where we've seen it move up and down. And we've had a nice little rebound here to start, I guess, from mid-April on. But please talk to us if you'd like to go into more detail.
Thanks, Adam.
Over.
Thank you very much, and great job as well. And once again, just to echo both what we've said throughout this meeting this evening, if you have any questions, thoughts, or concerns that you would like to discuss with your advisor, please reach out to them. That's what they're here for, to be able to help you, reassure you during these times of down markets. As Adam said, everybody loves it when it's going up. I think that's the consensus across the board, but unfortunately, we also know that it does have some downside. And it does come from time to time. We just don't know how much and or when. And that's another reason why we diversify and allocate such as we do to fit your needs. But anyway, with that being said, ladies and gentlemen, that concludes our meeting for this evening. Once again, we thank you very much for attending and hope to see you on our future meetings in moving forward. So once again, from One2One Wealth Strategies and all of us, thank you very much for attending and have a great evening.